the Companies Act, incorporation of companies and matters incidental thereto. So this part tells you about what is required by law when incorporating a company. Section 3, modes of forming incorporated company. Subsection 1. One or more persons may form a company by A. Signing and sending to the registrar 1. Articles of incorporation. 2. An application in the form set out as Form BRF 1 in the 6th schedule. BRF 1, that is business registration form that you fill out when forming a company. Let's look at articles of incorporation. I look up the term articles of incorporation on Investopedia. What it says. What are articles of incorporation? Articles of incorporation are a set of formal documents filed with a government body to legally document the creation of a corporation. Articles of incorporation generally contain pertinent information such as the firm's name, street address, agent for service of process, and the amount and type of stock to be issued. Articles of incorporation are also referred to as corporate charter, articles of association, or certificate of incorporation. Alright. We want to look up the unfamiliar terms, not just to read the laws. Alright, so one or more persons may form a company by A. Okay, we see this, the articles on the BRF form. B. Otherwise complying with the requirements of this act in respect of registration to such a company. Okay, subsection 2. Such a company may be either A. A company having liability of its members limited by the articles to the amount, if any, unpaid on the shares respectively held by them in this act term, a company limited by shares. Or B. A company having the liability of its members limited by the articles to such amount as the members may respectively thereby undertake to contribute to the assets of the company in the event of its being wound up. In this act, it's termed a company limited by guarantee, whether or not such a company has a share capital. Now, from the information I gathered, a company limited by shares is one that is set up to make money, and persons might invest in it, and when the company makes a profit, they may sell their shares in the company for money, and sometimes the company may issue dividends, that is, give part of the profit to the shareholders, those who hold shares in the company. As for the company limited by guarantee, to understand is that this type of company is usually in the form of a charity. It's non-profit. It may be a trade association, maybe a church, some other non-profit entity it could be, and anyone who had contributed to it, they may get back their contribution if that company is being wound up, it's being sold and its assets sold off. All right, that's my understanding of it, of these terms: company limited by shares and company limited by guarantee. Now C, a company not having any limit on its liability of its members in this act termed an unlimited company. So you have company limited by shares, company limited by guarantee, and unlimited company. Capacity and powers. That's section 4, capacity and powers. Subsection 1. A company has the capacity, and subject to this act, it has the rights, powers, and privileges of an individual. Okay, so the company, it can own money, it can own property, it has its own tax registration number, its own bank account, it can sue a person or another company, it can be sued by a natural person or another company, because the company is a legal person. Right. Subsection 2. A company has the capacity to carry on its business, conduct its affairs, and exercise its powers in any jurisdiction outside Jamaica to the extent that the laws of Jamaica and of that jurisdiction permits. Okay. Subsection 3. It is not necessary for a bylaw to be passed to confer any particular power on a company or its directors. Bylaw. I looked up the word bylaw online. What it says here, it's a regulation made by a local authority or a corporation. It is a rule made by a company or society to control the action of its members. Alright, so that's a bylaw. So it is not necessary for a bylaw to be passed to confer any particular power on a company or its directors. Subsection 4. The section does not authorize any company to carry on any business or activity in breach of any enactment prohibiting or restricting the carrying on of the business or activity. Alright. Now, let me look at this again. This section does not authorize any company to carry on any business or activity in breach of B now. In breach of any provisions requiring any permission or license for the carrying on of the business or activity. So the company is not allowed to breach these, right? If the license limited to certain activities, that's what it should do. It cannot carry on activities that are prohibited for that company to carry on. So that's what A is saying. And B, it cannot carry on any activities for which it does not have a license or any activities that the license prohibit. Power reduced. Section 5, power reduced. A company shall not carry on any business or exercise any power that is not restricted by its article from carrying on or exercising, nor shall a company exercise any of its powers in a manner contrary to its articles. Alright, so in the article of incorporation, it says what the company is set up to do. The company, it shall not carry on any business that the article says it's not restricted. That is not restricted. Alright. It first of all, I know that it cannot carry on any business if the article restricts those activities. But here it says it cannot carry on any activity that is not restricted by its articles from carrying on or exercising. Well, I guess that's what that is saying, is that the company cannot carry on certain activities, even though the article has not restricted the company from carrying on those activities. Has not specifically restricted the company. I guess, for example, if you have a company that's set up to repair motor vehicles, and the articles do not restrict you from fixing household plumbing, but at the same time, the company should not go ahead and repair household plumbing, even though the article does not say you cannot repair household plumbing. I guess you should stick by the activities or related activities, activities related to that outlined in the article of incorporation. That seems to what this is saying. Alright. Validity of acts. For the avoidance of doubt, it is hereby declared that, unless otherwise specified, provided in this act or any other enactment, an act of a company that is contrary to its articles, including the transfer of property to or by another company. So, for the avoidance of doubt, it is hereby declared that, unless specifically provided in this act, so unless there is some specific enactment or specific restriction, the company shall not be invalid by a reason only that the article is contrary, but that the act is contrary to its article. So, contrary to its article shall not be invalid. Okay. Now, this seems to be saying that the company carries out certain acts that is contrary to its articles. Right? These acts shall not be invalid by a reason only, okay, that the act is contrary to its articles. So it is invalid, but there are other reasons other than saying it is in the articles not to do so. That's not the only thing that makes the act invalid. Well, that seems to be what this is saying. Now, Section 7. No person shall be affected by or presumed to have notice of knowledge of the contents of a document concerning a company by a reason only that the document has been filed with the registrar or is available for inspection at the office of the company. So no person shall be affected by or presumed to have notice of knowledge of contents of a document concerning a company by a reason only that a document has been filed with the registrar Alright, so that will be it for now. We'll continue reading the Companies Act and the Articles of Incorporation next time.